Is your invention protected? Is the art of IP working for you or against you? Welcome to the My Product Developer podcast, Prototype to Payday, the show where great ideas find their way into the market. Today, we're diving into one of the most crucial yet often overlooked steps in the product journey, protecting your invention. We're joined by Dan Nevrivy, founder of Nourivny Batten Law Group, a leading intellectual property firm that's helped startups, inventors, entrepreneurs protect what they've built. Whether you're patenting your idea or prepping for licensing deals, this is an episode you can't afford to skip. So tell us, what led you into IP law and founding your law group?
Well, it definitely wasn't necessarily part of the plan. Um, so, uh, so I was, I'm a biologist. I think at my core, and never envisioned becoming a lawyer one day. But I was in graduate school in Oregon. Uh, I was doing a PhD in molecular biology, and I was in a molecular pharmacology lab, and I think I was probably into my fourth year. So I was sort of starting to see the light at the end of the tunnel. And usually at that time, you're thinking, go work in industry in science, and I was conducting, scientific research at the bench in the laboratory, or go do a postdoc and become hopefully a professor somewhere, teaching and doing research. And so I wasn't quite sure or convinced that that's the path I wanted to take. In science, when you're doing research, I mean, it's like a roller coaster. Everything is dictated by the results that you achieve from your experiments. And my research was going really, really well, but it was sort of a roller coaster because you have to do so many experiments, and then so much is sort of left to chance. And so you might, and we work really, really hard in our laboratory, like probably like 80 hours a week minimum. And so you would work weekends, nights. I mean, it was like all consuming. And so it could be frustrating when you spend like the whole weekend when everyone's going to the beach or to the mountains, and then come Monday, it's like all my experiments failed. And my friends had fun. But then obviously the highs are really high, when you have those, eureka moments, and you make new discoveries. And so I was a little bit torn. And so I was at a scientific conference. It was called the Keystone Symposia. And this was actually in Taos in New Mexico, in my field. And so I was really just not sure exactly what I wanted to do when I got my PhD. But I met this guy who was there, and he was in the same research area that I was in. It's a postdoc at Johns Hopkins, and we were talking. I think we were having a beer or whatever. And he's like, "Well, did you ever think about going into patent law?" And I was just like, "No, I've never thought about that. It didn't even occur to me." And so he had sort of introduced that concept to me, because I think some of his friends or colleagues at Hopkins had after completing their PhD, went to join IP law firms and work as technical specialists, and became lawyers eventually, or patent agents. And so it was sort of at that time too, in the early, late 90s, early 2000s, when there was this thing called the Human Genome Project, where companies and researchers at the NIH were sequencing the human genome. And so there was sort of this explosion of information about human genes, and patenting those genes. And so there was a lot of activity in the IP space over human genome. And so I was actually in a laboratory where we had discovered novel genes. And so, in fact, one of the genes that we worked on and discovered is the target gene for this CRISPR therapeutic called Casgevy. And so, of course, at the time we had no idea that could be a therapeutic, because CRISPR didn't even exist. and we barely knew what the gene did other than it was a repressor and interacted with certain proteins. But in any case, I was sort of well suited because of the Human Genome Project at that time to enter the field because they were looking for like a lot of molecular biologists. So I was like, this is really interesting. I'm going to start thinking about this. I think at that time I went, after that conference, I went to the library, which was right across from our academic building, and got a book about biotechnology patent law. At that time, people actually went to libraries for information. Yeah, and there was actually a book there on it. And I'm like, this is perfect. So I started reading it, and of course, I was doing my research too. And then, and then we had a retreat at the coast in Oregon, and I gave a presentation for my research, and I actually got an award for best graduate student presentation. So, and what came with that was like, I think it was like $1,000 of money that I could use to go to a conference, like no strings attached. And so I got this award, and then literally, I think like that day or that week, I'm online looking for. I was ordering some cells for an experiment, and then there was this biotechnology patent law conference in Arlington, Virginia, that was being sponsored by the company that I was ordering my cells from. And so it's like, okay, I just got $1,000. I got to figure out what I want to do. Maybe I could take that money and go to this conference, right? And maybe learn more and meet some people and talk to them about this career option, because I had talked to nobody, like no real people who did this job. And so, so I told my professor about it, like, hey, do you mind if I use this money to go to this patent law conference in Washington, D.C.? This is actually in Arlington, Virginia. And he just looked at me like, okay, why? So, but generally was pretty supportive on it because there were no strings attached. Of course, they want you to stay in science and sort of be there, just follow in their footsteps. But I wanted to sort of be somewhat diligent, explore the options. So then I went to this conference, and I was like, kind of the only student there, and I was actually talking to real lawyers. And it was really interesting, like sort of unlike any scientific conference I'd ever been in, because people are actually yelling at each other.
Whoa, okay. Can you go? What do you mean by they were yelling at each other?
Well, there were a lot of topics. And so I'm just trying to remember, there were certain topics about royalties and, sort of, patent rights and being able to, instead of, having these obligatory licenses. And so it was sort of contentious, right? Because the idea of a patent is, it's fully exclusionary. So if you have a patent, nobody could practice your invention. And so, but that's not the case in certain countries. And then certain, academics have ideas about that too. Of course, things have changed a lot since then. But anyway, it got pretty heated. And so I was like, what's going on here? This is interesting. But of course, there was a lot of discussion about gene patents and things that were like right up my alley, like the science of biotechnology. So it seemed like an interesting thing to do and consider. Like, oh, you can sort of you can take your scientific knowledge, build off that, but then also help innovators or companies protect their inventions. And then I think one of the organizers there, I had like a few words with him. And then after the conference, I reached out to him to see he had a firm, and I asked him are you guys looking for people like me? And it turns out that they were. And so he's like, send me your resume, which I did. And then and then basically they said, okay, come in for an interview. And this is kind of an interesting period too, because it was like around September 11th. So I had an interview at the firm in Washington, D.C. It was scheduled for maybe September 19th or something like that. And so September 11th, 2001. So basically, September 11th happened. They stopped flying planes. And then I'm getting ready to go to Washington, D.C. on a plane. It's like the first or second day that they started flying again. And literally, I was like, there were like 3 or 4 people on my plane to Washington, D.C. So it was a bit surreal. And so, you go there. I interviewed at the place. It's a very good firm. It's like an IP boutique. And, I'm sitting there and, the partner's like, so, and I was in Oregon. So mind you, like, on September 11th, like it was already over by the time I woke up. So the partner's like, so you really want to come to Washington, D.C.? Sort of, everybody there just wanted to probably go to Montana. And I was like, oh, yeah, of course. So anyway, so I got the job. I started working there, and then worked there during the day, went to law school at night, and then started my firm in 2008. It was, just sort of on the cusp of the financial crisis. And so I sort of looked, I was definitely keeping my eye on what was going on in finance. And I was like, this cannot be good, what's about to happen. And so, and I was sort of at a point where I'd been working at that firm for like 7 years. And so, I felt like I was competent enough to go out and start a firm and, be able to do the work and also market and get clients. Of course, there's always like a lot of uncertainty there, but I thought, well, if there's a time to do it, now might be a pretty good time because I just don't know what the future is going to hold, right? Nobody did. So that motivated me to, I saw like an opportunity to, go out there and launch a firm because, sort of technology had changed too. It allowed firms to be like a lot more streamlined. Like we don't have paper files anymore. You don't need like huge infrastructure to service clients like you used to. And so I was like, okay, now it might be a good opportunity. So let's see if that's going to work. So that's what sort of spurred me and motivated me to do that. And yeah,
So now you've been practicing patent law for, well, in your own firm for 17 years. Did I get that right?
it's been that long. I guess, yeah, it's been maybe it'll be 17 like later this year, I think September. Yeah. Yeah. It took me a few months to start actually practicing in my firm. I was faking it for a few.
I've been there, done that. We all both of us have started businesses like that before.
Right. You have to, yeah, you're not really practicing until you have clients.
Exactly. So I just want to kind of go into this. So what kind of IP do you specialize in? Because I know that we had talked about that we do more product development, and you had a very specific area that you specialized in.
Right. So our firm is very specialized. Our focus is in the life sciences industry. So anything biotech or pharma related. Um, and we also do some mechanical work as well. So we've done some therapeutic devices as well as consumer products, consumer products types of devices. Um, and we also work with some foreign lawyers, so they will send us some cases sometimes from abroad where it could be totally outside of a life science area where it may be like electrical or in the oil and gas, like different types of pumps or what have you. So just I mean, it really generally, in terms of how we market and position ourselves, it's for biotech or chemical life science work, but we've done some other work as well.
Perfect. Now I wanna ask this question. This is one of my favorite questions to ask. But what is the most creative invention that you've helped protect? Now, whether that's bioscience or something crazy like we were talking to one person, they said there was a cat door, and that was their favorite thing that they had done, and it's like, okay. But what is your most favorite thing?
Well, I think definitely everything that sort of comes through the door is like very creative, very innovative, especially in the life sciences space. Um, but definitely in other areas too, like consumer products, it could also be like highly innovative as well. It's just, if it passes the threshold for patentability, it's, has to be novel, non-obvious, and useful. It's patentable. But I'd say kind of the interesting thing, like creative wise, was, I would say there's probably two. Like one's a microbial fuel cell, which before I started working on that case, I had no idea, really what a fuel cell was, and I mean how you would, combine microbes with it. But it was really interesting, done by some pretty talented microbiologists who, figured out that you could take, Pseudomonas. It's a pathogen, right? It's not a good bug, but it's like a super bug, really. It can do anything. And like you can literally put it in diesel fuel and it will thrive, right? And so what they did was they took this Pseudomonas and then they genetically engineered it with various genes, either knocking out or overexpressing, to get it to, and the Pseudomonas has these little things on the outside called pili. They're like little tiny appendages. They could get these Pseudomonas to attach to an anode and deliver electrons. You feed it like wastewater or any organic, it'll eat anything. And then it will transfer electrons from the pili to the anode and generate electricity. And so this was sort of at a time, in the 2010s when, clean tech was kind of a hot thing. And so and it actually worked, right? So I thought that was pretty wild. It's like, it's like, have you ever seen that movie like Back to the Future, where he's got this DeLorean and he just throws a bunch of garbage in there and it just goes?
Yep. I'm still waiting for that invention to come out.
Right. Yeah. I was thinking that this microwave fuel cell, it's like, yeah, imagine you have one of these things, like just sort of hook up your septic system to it. And it's like, it's totally like, clean and renewable. And, but I don't know if the output's that much.
Yeah, that'd be really cool. Have were they? I mean, so right now, what are the use? Is there any use cases that you've seen it in so far, or
I mean, I think it's like a lot of things. Like it's like and that's true with a lot of patents. I mean, you can have, you proof of concept, you file your patent, and then you try to go out there and market it and sell it and develop it, right? And, filing the patent and showing proof of concept is really like the easy part, but commercializing it is really the hard part. And so I think they were able to license it, and then the company was going to take it and then try to use that IP to leverage to raise money and so forth. But I don't know if they were,
yeah,
successful. But that's true of a lot of inventions, right? Like I said, the easy part is sometimes making the invention, getting the patent. We got them the patent, and then but then commercializing it. That's really the difficulty.
yeah, absolutely. We definitely see the same thing with our clients. And we spend so much energy to not just be able to design the product, but to make sure we have a plan in place for them if they want to go down that path of here's how to get it to market. Make sure we can see both sides of that. Uh,
Right.
but what was the intended purpose for? Was it to for the septic, or was there another intention that they were planning to use it for?
Well, I think, when we draft the patent, we try to make it as broad as possible. So, I mean, you can imagine so many different applications of it. I mean, you've got a system that will be able to generate electricity from organic waste or wastewater. Then it's like, well, what do you need electricity for?
Yeah, that's a pretty. That's one of the cooler ones. I mean, it's a lot more technical than most of what we do, but that's one of the cooler, like world changing ideas that I've heard. Um, yeah, it's almost like burning trash, but through a more. We don't have the byproduct of combustion, so that's a.
Yeah, I mean, another case we worked on too. It's like through a university, and it's also a microbe. Like you can do a lot with microbes. Like they're very versatile, and this is using salmonella to vaccinate. So you can administer like an attenuated salmonella orally that will deliver an antigen through a recombinant outer membrane vesicle, which will then present it to like the cells in the immune system that will generate an immune response, right? Um, so I think that's pretty cool too, because there's a lot of engineering that goes into sort of modifying. And you think, yeah, I'm going to give you some salmonella to make you better. uh, yeah, it's a lot of it's very innovative. Yeah, microbes are really really versatile. Um, and yeah, I mean that's still like in the development stage, and so we'd like to see what happens there. But it's an interesting idea because if you think about it, your immune system is like um, primed to detect pathogens and form an immune response with it. So if you can engineer those pathogens to deliver specific immunogens, right, to prime your immune system for vaccination, it makes sense. But then do it in such a way that it's going to make like a very robust immune response. Um,
Yeah, it's clear that you're very passionate about this, and we could talk about this all day. I'm gonna kind of switch the gears up on you a little bit here, and get a little bit more into the back to the patent side of the house. Um, what's the difference between a patent and a trademark?
Well, patents are, they protect inventions. And so, the invention could be a composition of matter, could be a new process, it could be an article of manufacture. And it just has to be novel, non obvious, and useful. Um, and, the patent gives you the right to not practice it, but exclude others from practicing your invention. Um, Whereas the trademarks are, really just like distinctive, could be words, phrases, symbols, designs, like color, smells that you can use for a product that identifies and distinguishes a product or service as being from a certain source. So it's more of a branding um, tool.
And where do copyrights fall in there?
Copyrights are protecting, creative works, like music, art, images, drawings, and things of that sort. Two
So,
separate offices handle them. Like one's the patent and trademark office, and then there's a copyright office if you want to register your copyright.
oh, gotcha. So, does software typically fall as a patent or a trademark or a copyright? Because you have like a lot of lines of code and everything, and there's art to it, but then you have the functionality. Well, is there, yeah.
Yeah, a lot of software types of apps and innovations can be protected by patent, but they can't be abstract ideas.
Mm.
But they also could be protectable by copyright as well.
Yeah, that makes sense. So what's stronger, the patent or the copyright
Hmm.
for software
I
or
mean,
for really anything, I guess?
yeah, good question. I mean, it depends. Like copyright can be very, very strong. Especially if that's the nature of what you're trying to protect, some artistic or creative work. Um, Patents can also be strong, but they're more expensive to obtain and harder to enforce as well.
That's really good insight. I appreciate that.
But I mean, you should try to pursue. I mean, if you have an opportunity to patent, if it's a composition, like I said, a new process, an article of manufacture, and if it meets the statutory requirements, you should definitely consider patents.
Yeah, that makes sense. When do you think somebody should be acting on a patent versus working through their idea, and like how much thought should you put into something before you start a patent?
Well, I think the question is like, well, should you patent this or not? I mean, the patent, you have to think about the patent. The patent provides potentially exclusivity. And so, will the patent provide some exclusivity for you, for your product? And let's say that, let's say that you're going to develop this product, and the the field may be so crowded that you're only going to be able to protect exactly what it is you're doing, right? And so if you want to protect exactly what you're doing to prevent someone else from doing exactly what you're doing, then you might consider a patent. Um, but if it's really easy, if your patent's going to be really narrow, it could be fairly easy to design around, and therefore like not provide much exclusivity for you. And so then you might say, well, maybe it doesn't really, the patent doesn't really provide that much value for the exclusivity purpose, right? And so, of course, to answer that question, you have to have a pretty good idea of how your product fits into the marketplace and everything else that's out there to know like what kind of scope of protection you're entitled to. Now, if you're entitled to a fairly broad scope because it's perhaps highly innovative, then that may be a strong indication that you should get a patent. But exclusivity is not the only reason to consider getting a patent. Ultimately, that's what a patent does. It provides some exclusivity, right? But that's not necessarily, especially if you're an entrepreneur, like the only reason you would consider getting one. So have you ever seen the show like Shark Tank before?
Absolutely, yeah. I think that's the main thing that drives people to product development.
Right. So, I mean, like of all the panel, like in the Shark Tank, like there's one person that always says, "Well, do you have a patent?" Like I think it's like Mark Cuban. I think that's his favorite question. Do you have a patent? And
Right.
so like the investors are gonna ask, "Do you have a patent, or have you filed a patent?" And even though they're not going to be like as knowledgeable sitting there at that point in time to know like how much exclusivity you're going to have, but they
Right.
just want to know if you have one. And so if the answer is no, they're going to just kind of write down and scribble something down and say, well, maybe they might pass on it.
Yeah, we've
So,
definitely seen that with like licensing, like any type of licensing or selling a business or product. Um, the patent question comes up almost immediately. It's like, well, if we don't have it protected, then how can you sell me your company, or how can you sell me, uh, how can we do a license deal? Things of that nature.
Right. Yeah, and it's like the threshold question too. Like, do you have a patent? And then it's like, okay, yes, we do. And then, depending on how much money is at stake, in an investment, if it's like, like an angel funding, like, $50,000, they're not going
Right.
to dig, they're not going to dig deep into that and analyze, the merit of your patent and the strengths and weaknesses. But if they're going to invest like 50 million, they're going to hire, people like me to go through and really scrutinize everything.
so Dan, is there any situations where you would recommend not getting a patent?
Do I want to run myself out of business here?
Yeah, I realized that as I was asking the question, but I'm like, it was just something that's like, as you were talking about it, I'm like, oh yeah, but I don't know. I don't even know the answer to that. So
Well, I mean, I think, of course, there's going to be situations where, I mean, as a lawyer, if I'm talking to a client, um, it, and I've learned to sort of be fairly non-judgmental about inventions too, because you just never know. Like you think that there's this great thing, but then it can go nowhere, or you sort of look at something like, yeah, I'm not sure, and then it's like the next biggest thing. So I've learned to sort of, not try to, have too strong opinion, just like tell me what you have. But if you've got maybe if there's something that, it will provide like little or no marginal benefit, or maybe like they think that, oh, this is novel and it's never been done before, and then you do a patent search and you see things that are like right on point to it, or extremely close, where it's like, it's if it's not um, if it's not lacking novelty, it's for sure obvious, and it will be like a hard hurdle to go there. Like, or it's just like common sense that you could come up with that. You know, I would say, you're better off just, not putting those resources into patenting, and instead just put it into like maybe branding, right? Like trademarking, creating a product, creating a brand, marketing, things like that. Um, if the patentability of it's kind of questionable.
So, do you think the pet rock is a marketable idea? Like, do you know if that was patented or if it is patentable?
I don't think so. I mean, it's funny. Yeah, it's funny you mentioned that. I don't think you can get a patent on that. Just because it's a product of nature. It's a rock, and so just by putting
But
it
you
in
could
a box,
trademark it, right? You
yeah,
could
trademark.
trademark the name or the idea, I guess.
Yeah, I mean, the article of manufacture could be like a rock packaged in a box in a certain way or presented in a certain pedestal. But again, someone, I mean, definitely you can draft a patent on that, I'm thinking, uh, but uh, you know, it may be an uphill climb. And but the funny thing is, like, there used to be like a lot of what people complained about. They would call them like so-called junk patents out there. And my one of my law professors, who's now like the chief judge of the Court of Appeals for the Federal Circuit, did like a lot of scholarly work in this area. It may have helped contribute her get appointed to that position. Um, but there's a lot of patents out there that are just like, come on, like a method of swinging a golf club. Like, no.
Hmm. Interesting.
Patent office has done a better job of sort of, just not allowing and not granting certain types of patents anymore.
Yeah. So, when do you think it's the right time for some? I think we kind of asked this, but do you think there's like when do you recommend that somebody goes ahead and does move forward with a patent? Like, what are the signs that you go, this clearly makes sense to patent this?
Yeah, I think when you think that it's close or ready, almost ready to be patented. So now, in order to have an invention, it's more or less a mental act for the most part. It's conception, and so you can have an invention, in your mind, as long as it's fully fleshed out, and you can describe in words how to make, and use the invention. The conception of the invention is for the most part like a mental act. Now, if there's some unpredictability about whether something will work unless you reduce it to practice, then you're talking about, well, making a prototype of it, right? So whenever something is ready for patenting, you know, I think that it's a good time to start thinking about it, but maybe even better a little bit before something's ready for patenting, because if you're making a product, there are certain things that you need to do. There are certain tweaks that you need to make to your product until it's finished and final, right? And sometimes if and you may not be thinking about patents at all during that stage, right? But you should be, if you're planning to patent something, because and here's a reason why. you may get to the end of the road on your product and have it fully fleshed out, developed. Yeah, this is what it is. This is our invention. And then you find out that maybe it's not novel, right? Or maybe there's some other patent out there that's going to block you from commercializing it, and it will impact your freedom to operate. So in other words, you've created a product you put on the market, but it's infringing someone else's patent. And so when you're in the development stage, it's good to assess, what the landscape, what the IP landscape looks like, so that you can, if you need to, design around patents that may be out there that could impede your freedom to operate, and make changes in your development. So I would consider that the best practice, but certainly not something that, especially entrepreneurs, if they might not be aware, especially newer entrepreneurs or creating new products for the first time, they're not going to be aware of sort of like a best practice in terms of their product development.
Yeah, now I'm not sure if I understood that correctly, but it's not like you said the best time to patent is when you think you're going to patent.
Well, I think the best time to, like, if in terms of filing, is sort of when it's ready for it's when it's ready to be patented. So like when you're ready.
What would that look like, right? Like, how does somebody, like, for you, I think you have a pretty good idea of what it looks like when it's going to be patented, but for someone that's never done this before, what would be like a sign that it is ready to patent? Is it during the conception stage? Is it right before it goes to manufacturing? Is it after it's on the market? Like, at what tier are you saying, okay, we need to have it before this period expires or before we do this step in the product line stage?
Yeah, you can. I mean, and you can have a multi-stage process too, where you could be filing multiple patents along the way. Like, let's say you've got, version one, and it's fully fleshed out, in your mind, and you just have to sort of maybe build it and test it. Maybe you can file it at that point. But then let's say once you test it, it's like, no, we need to make a tweak. Then you file it again. You can make another filing, right? So um, you don't generally want to. You want to generally try to file it, earlier than later. At least when at least when you think that it's ready for patenting. Now, it might not be ready for commercialization, right? That's two separate things. Being ready to be patentable and ready to commercialize are two different things. But you also need to kind of think about, well, how far away are you from commercialization too? Like, let's say you've got, version 1.0, and you think that might be it, but you're going to test it, you're going to do more work, and maybe it's only going to be like version 4.0 that's going to be commercialized, and maybe that's like 3 or 4 years away. And so in a situation like that, you got to be real careful and mindful about what you file on and the timing of it too. So a good strategy for entrepreneurs, especially when they're still in the development stage and maybe doing some more testing, is file provisional applications, because you can keep those secret and let them expire without converting them, right? Because if you convert, like, let's say you file a provisional application and you have to convert that into a real application that gets examined within 12 months, and then 6 months after that it can publish. So if it's publishing and you're still in development and you haven't really sorted out what the product's going to be, you've just created, like, but it's going to be close to what your version 1.0 is. You've just created a bunch of prior art that's going to maybe make it more difficult for you to patent version 2.0 or 3.0, because it's already in the public domain. Patents will publish unless you file a non-publication request in the US, which you can do. But it's just a lot of things to really think about and consider. There's no really one, there's no like one size fits all to it. It really depends on, specific the specific circumstances and sort of where you're at in the development, what more needs to be done, when do you want to commercialize?
When we spoke earlier, you had talked about patent strategy being a little like a work of journalism, which answers 5 fundamental questions of the who, the what, the when, the where, the why of the story. Can you talk a little bit about how that relates to patenting?
Yeah, I mean, I think the reason I mentioned it because I've done like a number of like IP strategy types of seminars, and in sort of preparing for it, I think that there's really like sort of like in journalism for like a journalistic work, there's really like five fundamental questions for IP strategy. But of course, then you get that's at the very high level. But then for each, it's almost like okay, you got one question, one of the fundamental questions, but then there's like 28 subparts to it. But really the fundamental questions, I think there's five in my mind. It's whether to file or not file a patent application. What are you going to file your patent application on? Um, you know, how are you going to file that patent application? So there's many different ways to file it. When are you going to file the patent application? And then where are you going to file the patent application? And so to me, these are sort of like at a high level, these fundamental strategy questions. And it sort of relates a bit, we talked, just a second ago about if you're, when do you file or, what are the things you think about? And those are a lot of the things you think about. Like, okay, should we file or not file? I mean, you can keep it as a trade secret. You don't have to file it. What are you going to file on? Like, what is the actual invention? And sometimes people think that, well, this is my invention. But that might not really be what the invention is. The invention might be some little piece of it, of something that's already been done before. And that it's that little piece really that's the real invention. So you need to sort of be aware of the what, and then have like a certain scope around that what so that you have like a good protection for that what, right? And that you can really, make sure you spend a lot of time describing that what in your patent application and not really miss it. It's good, and you need to know that before, as a best practice. And then, how are you going to file it? You want to file as a U.S. provisional first, then do a non-provisional, file a PCT, which is an international application, then go into different countries after that. Do you want to do a slow track, which is basically there's a huge backlog at the Patent and Trademark Office now. Your application will sit there for years. You might get it issued 4, 5, or 6 years after it's filed. You may get some patent term adjustment because of those delays, or you want to do a fast track and do like a track 1 or prioritized examination or petitions to make special, where you can go to the front of the line if you pay a little bit more money, and if you're like a certain age. Like for example, I'll tell you, there was one case that I filed. It was a prioritized examination. They want to go to the front of the line. It was a packaging type of invention. I think we filed this case like maybe April 29th, and we had a notice of allowance by like May 24th, like 3 weeks.
Whoa, that's the fastest I've ever heard of it going through. What was the reason for the for them expediting it? There we go. That's the word.
Well, I think, it's expediting is a good idea and it's a good strategy, especially for entrepreneurs, if they want to try to get their patent, more quickly, right? And it could help them for fundraising. It's a strategy too, because, like I said, there's a big backlog at the patent office to examine patent applications right now. So it could sit there for years, and if you're not that patient, or if you're like really old and might get sick, like I need to get this patent, or strategically speaking as well, paying that extra money and going to the front of the line puts a little bit of pressure on the patent office to expedite that case and handle it quickly. And so it sort of puts them a little bit under the gun. And so that could give you some advantages in prosecution because, they're under time constraints to either reject or issue that quickly. And so, it gives the applicant an advantage.
What age do you get the expedited benefit?
For a petition to make special, if one of the inventors is 65 or over, you can file what's called a petition to make special. And we've done a few of these as well. And, you basically just go to the front of the line. So it's sort of like the track one, but there's no extra fee involved. So it's like senior citizen discount.
That's awesome. That makes sense. You
Mhm.
gotta get your IP approved while you're still alive for you to be able to benefit from it.
Right. Yeah. I mean,
What I'm hearing is if I want to invent something, I should invent it with someone who's on Social Security.
Exactly.
right. Yeah. Just if you're looking for like a good collaborator, find some older guy or gal and say, hey, do you want to help me with this? Right. And can I see your license first to see your age? Just check it.
License, birth certificate, Social Security number. No.
Yeah. Were you born before 19? I don't know what it is. I can't do the math that fast. Yeah. Yeah,
I
but
think it's 1965 right now.
1965 or no, 1960.
Yeah, no, you're right. 1960. You're right.
Getting worried.
Sometimes my math doesn't math properly.
Okay. Can you share a time where you saw someone get themselves in a bit of trouble because they didn't have the IP planning correct or didn't file a patent?
Mm-hmm. Yeah, I mean, it happens all the time. And that's where you have to really be, strategic and, sort of get to those like 5 questions, fundamental questions, like, in advance. I mean, you can get really granular on things too. Like in country specific laws, right? I mean, every country has their own laws on patents and they're slightly different, although over time, I mean, at least in my career, I've seen more of a convergence or harmonization between different IP laws for different countries, but they're all different. But one fundamental is like, well, where are you going to file this patent application? And so we had a client many years ago. We didn't like do like the initial filings, but we took over, and then they had a product. It was a pain product, and they had other products as well. But they were looking to license or perhaps even sell the company. And there was a Chinese company that was really, really interested in their product and wanted to move forward. And as luck would have it, they didn't file any patent application in China. So they just backed out. They're like, we can't do it, which is sort of more like an about face about China, because it used to be like, they didn't really care about patents, and they sort of, like they, patents for, they would violate them. But this company was a Chinese company. They wouldn't move forward because they were worried what other companies could do in China against them if they didn't have a patent. And so, when you think about it, when you're thinking about filing, you have to think ultimately, what is the end game here for your company or for your product? What's the end game look like? And if the end game is, well, I'm gonna develop this product like soup to nuts and own it throughout, and I'm only going in this market, and that's all I care about, then you don't need to really think about, where else to file. But if your end game is, well, we're just developing the technology here, and we're gonna, or even the product, and we're hoping to like partner or hand this off to someone else later, that someone else later might care about where there's patent protection. And in the field that I'm in the area that I work, I mean, therapeutics, I mean, generally you want to file like in the major markets, but then it's not unheard of and it's somewhat common for companies that they'll file in, like 50 or 60 countries for their IP. And maybe they're not going to be the ones developing that or getting approvals in those countries themselves, but they're going to partner with, an MNC who has like the deep pockets and can spend, several million to get like worldwide patent protection.
I have a question I want to hit because we're starting to run out of time here. But I wanted to ask you about AI and how that's changing IP law.
Ooh, that's excellent. Certainly, yeah, AI definitely disrupting everything. I mean, I could see it in a couple of ways. Like on the one hand, AI is certainly disrupting innovation. Um, I think it's certainly accelerating innovation because the AI is like has perfect knowledge of really like depending on what's trained on like perfect knowledge of all the prior art. So you can ask it lots of questions and get lots of information. You can, for example, in the space that I'm in, you can take crystal structures of proteins and in silico design like therapeutics against those targets. I mean, you could even take like, let's say it comes up with sort of like some novel compounds or targets. You can say, okay, well, here's this, chemical structure. If I start from benzene, how can I make that compound? And it can give you like a route of synthesis, which, I mean, I wasn't a very good, I'm not an organic chemist, but I have my Bachelor of Arts in chemistry, but like it would take me a while to figure out how to synthesize that. And you can just ask AI, it could give you like a route of synthesis. If I start from benzene, how can I get to this compound? And it will like, boom, give it to you right there. It's amazing.
How accurate is it though?
Well, I don't know. It looks accurate if you look at it, because it talks about the different reaction schemes, the different names of the chemical reaction. It gets very nuanced. Like you need to protect this group, so you need to do this reaction. I mean, obviously, that's the thing with AI, especially if you're using it, as an innovative tool. You have to validate whatever it's telling you so that it's not some hallucination. And so, but it certainly speeds up, right? I mean, even just just thought experiments. You can use AI for just even thought experiments and see if there's any weaknesses or if the rationale or the underlying science or your principles are sound. So it's pretty amazing, right? Pretty amazing. I mean, in terms of like the practice of law, I think that's also interesting because I think clients can, sort of use it as well to, instead of calling me or their lawyer, they could just talk to the chat GPT and ask like, questions that they might be able to get from their AI, right? Legal questions. Now, of course, I would say, well, make sure you always, just talk to your lawyer. But certainly, it's pretty powerful, and it certainly could be useful. Now, I'm not using it to like draft patent applications, but I think some attorneys are starting to do that. I think that it's a little tricky because it may not give you the exactly what you want, so you have to it's a very if you're using it for drafting, you have to be very iterative with it and prompting it a lot, and it can will spit out something if you prompt it. But then if you're giving it anything confidential, you're just running some great risks because it may be training on that. So it's best for me just you can do it generally, but I generally just steer away from it because I don't think it's quite. I mean, I've been doing this for like 20 some odd years. So I don't think it's quite at the level of like a skilled practitioner for certain types of tasks. And I just rather just, do it myself, right? But where I think it's interesting though is that I think it can create like kind of a skills compression. So if you're like a new attorney, if you have now that you have access to this, AI, you can really kind of perhaps if you know what if you know what you know and know what you don't know, you can use the AI to really compress, the difference between you and someone who's highly skilled. He's been doing it a long time. Now, the danger there is if you don't know what you don't know, then it's a real problem.
That's said really, really well. Yeah, I think I always tell people there's three types of information. There's there's things you know, there's things you don't know. But we hire professionals for the things we don't know. And that's really the key is like, unless you have time and experience, and even then there's things we don't know. But that's really seems to be the only real safe way to kind of mitigate that risk of like just work with
Right.
somebody else that does have it. And even when you're building a team for investors, one of the fastest ways to get an investment is to focus on the team and not the product. Investors don't invest in products as much as they invest in teams. I think most people miss that. I'm a little off topic here, but it's just the where I've seen that really come into play is like with the investing side of the house.
Yeah, I mean, ultimately, it's the people that push it forward. So yeah, you have to be comfortable with the people on the team and that they know what they're doing. Um, I agree.
What are some of the new age risks that you've seen come into play recent? Like, is there any risks that you see changing or like new risks that are I guess coming into effect as technology and AI change?
I mean, for me, these are like really um, hard things to predict. Um, I think that with AI, there's probably going to be an acceleration in innovation. There's going to be a skills compression. So, in other words, like, I mean, if we just look, at the world, the United States is a leader, right? Is a leader in so many technologies and innovation. But, uh, how is that going to play out in a world where you can give AI to the rest of the world? I think they'll be able to, it will, because of this skills compression and knowledge compression, um, there could be some, catching up. I mean, easier for them to sort of catch up or compete or just, innovate. I mean, if AI accelerates innovation, it's going to do that across the board. I mean, I think that's a good thing. Innovation is a great thing. I mean, regardless of who you are or where you live, it's going to improve lives, I think, everywhere. But I do see that, um, it will help, it will lift, I think it will lift a lot of people up if they have tools and access to it. I do think that, at least for like entrepreneurs going forward, if they're going to be starting a company, launching a company, some of the risks I see are not so much like the technology or just like IP laws changing. I think it's especially now it's like it's geopolitical and it's macroeconomic. I think these are like the main risks for entrepreneurs today. I mean, the world is. I mean, it's changing. I mean, a lot of things are changing. A lot of established orders and systems that have been in place for the last 10 or 15 or 20 years are sort of being upended. So so there's a lot of disruption, um, and so it could impact. I mean, financing, fundraising. Like if markets go down, I mean, what gets killed the fastest or equity is in like risky ventures. So, you know, um, and then, so I think that's really like the real risks going forward. I think what entrepreneurs can sort of do to mitigate that is just be aware of them, um, sort of be flexible, be nimble, and have like contingency plans. Because the way that, like, it's like if you're starting a certain company, the way that you would think is like, well, I'm going to start this company and here's what these guys did and this is how they did it in the last 10 years. It's like, well, that world might be very different in the future. Like, you need to sort of be aware, I think, of all the geopolitical risks and macroeconomic risks. So I think that's the biggest. But at the same time, I think for entrepreneurs, like those times of upheaval and change create opportunities, especially if you could be nimble and proactive and contingency, because you're obviously you're oftentimes going against like established players that are already in the market, and they're not going to be able to adapt so easily to these changing circumstances or environments. So I think it creates great opportunity as well.
Perfect. So we're running out of time here right away. So I've got what I call lightning round for you. All right. So what I'm going to do, I've got about 3 questions here, and I'm just going to ask you, and we're gonna have a little fun here. What is the biggest myth about patents?
I think biggest myth is that, oh, I got a patent, now I can practice my invention. No, that's doesn't work that way. So, like, if you get a patent, it just means that you can exclude others from practicing that invention that's in your patent. Because, your product may be covered by your patent, but there may be some other patents out there that dominate you. So it doesn't give you any rights at all to practice your invention.
Oh, that's interesting. I never thought about that. The next one is, what is one thing an inventor should do before pitching their idea?
I think you got to get all your ducks in a row, you know, before you do that. And I mean, a lot of times, if you've already like filed patent applications or filed IP, and if you're pitching to, like, whether it's like, well, I'm pitching it to the investor council at my country club, or, well, I'm actually going to talk to VCs now, right? You have to be prepared, and you can't just walk into that. You have to have all your ducks in a row. You want to make sure that you have obviously a sound business plan, sound IP protection, sound IP strategy, sound analysis of the patent landscape to make sure that you have like freedom to operate. Now, of course, depending on how much money you're looking to raise, will depend on like how much diligence you're going to do. But the more money is at stake, the more diligence will go into scrutinizing your business and your IP, making sure that you've got your ownership in your IP locked up, have all the assignments in place, make sure that you've got, just a good strategy.
Thank you. Last one here. What legal mistake do you see that you wish most inventors would avoid?
I think, try to talk to try to, find an IP lawyer and talk to them earlier in the process rather than later in the process, for all the reasons that, we talked about today, right? Like, don't disclose your invention, don't put it on your website, don't get all the way to the finish line in your product development and realize that you can't commercialize it because there's freedom to operate issues. So I think the earlier, it's hard to do too, because I mean, entrepreneurs have like a million things that they're thinking about and doing. But if the IP is going to be an important piece, you want to talk to your lawyer just, I mean, very early in the process. Don't wait.
What products do you see that do the best, or what products have you seen do the best?
Mm. If I were like a really good judge of that, I would probably not be doing this. I'd be out there, I'd be out there making that. Uh, because it's just really hard. It's really hard for me to really predict. Because I work with like a lot of like PhDs, like just super, super intelligent guys, and they'll come up with these great, inventions. And, sometimes they don't launch, but they're really complicated. You're like, nobody could come up with that. I mean, you're a genius. And then, and then some guy like invents the pet rock, and that's it, right? I mean, it's just, you can't predict. Um, one thing I would say though, which is a strategy, is uh, if especially if you're an entrepreneur like looking for a product, um, the really hard thing is to invent like something totally new, right? Because you just first of all you got to come up with it and see the need, and then like I said before, um, making a prototype and getting a patent are sometimes like pretty easy, but actually commercializing it is really hard. And so one thing you can think about is like, well, let me just look out into the marketplace and see like what's actually working, right? What are some products out there that are just doing great, selling like gangbusters? And maybe looking at that and saying, well, okay, I'm not going to be, some unscrupulous counterfeiter, but I'm going to have like a me better strategy where I'm going to look at that product that's already out there, and I think that I could make a better product, or maybe you can make a cheaper product, or just make a small tweak to it, and see if you can carve some IP around that me better. Because ultimately, like with innovation, nothing is really like like never been done before. Like everything is always like an improvement on something else. And so, I think that's something, maybe something to think about. Like, look always for the me better.
Yeah,
But that,
I
how do you
agree.
see that?
Yeah, I definitely think that 99% of products today are in that me better or more better category. You look at the car. I always like to use the car. Like it's been produced for over 100 years, and every year they come out with better safety, better ride, better fuel economy, better tires, but you name it, better assist, better right. Now you got you don't just have TVs in behind the chairs, but now like you got TVs in 3 rows, and like I mean, whatever features you want, they figure out how to add it. So I think that just goes to show that no matter where things are, like there's probably a room for improvement. Look at power plants, look at any kind of like highly refined air. But I think the key, in my experience, is not looking to is to find the shortfalls and really chase down the shortfalls instead of just saying, "Hey, Brian, I want you to make a better engine," but really say, "Here's the shortfall in the engine that I want to fix, and here's my area that I want to improve," and we can go in and we can really help people because there's a balance there too.
I think it can provide like a competitive advantage too for new codes or entrepreneurs, because let's say a company's got a product out there, they might not be further innovating, and they're not maybe not really thinking about their product's doing great. So if it ain't broke, like don't fix it, right? But that's sort of a trap in thinking, because it can always be better.
Yeah.
Yeah. So I want to just say thank you so much, Dan. We're nearing the end of our allotted time. Was there any final thoughts that you wanted to give our audience before saying goodbye?
Um, just yeah, thanks for appreciated. This has been a lot of fun. Um, and yeah, I mean, if any listeners have questions about just IP law or what their strategy should be, or if they need any assistance, of course, they're more than welcome to get in touch with me. But yeah, just keep innovating, and yeah, hopefully, hopefully the world will be a better place tomorrow.
Absolutely. So if you want to get in touch with Dan, we've got his contact information and his website in the description below. Take a look. And if you want to develop a product, come see Brandon and I at myproductdeveloper.com.